there, Kim. What do you think? This is our last Fabulous Fridays. Can you believe it? This is number 8.
It went by so quickly.
I know, I can't believe it. So listen, we just want to welcome everybody that is interested in our Fabulous Friday series. And we want to express special thanks to the Montana 4-H Foundation and the Montana Center for 4-H Development for sponsoring this series for the 2 months we've been doing it. Today, what we're going to take a look at is deceased persons' accounts and how we can get access to them after an individual has died. And sometimes there's just not a real probate required for that. So we'll show you how. My name is Marsha Goetting. I'm the Family Economics Specialist for MSU Extension. And what I do is travel the state and do educational programs in the area of estate planning. And I haven't been doing a lot of that the last couple of years because we've been focusing on webinars. And I look forward to getting out there again. And some of you, if I wind up in your county, you come up and say, hi, I did your Fabulous Fridays. And I would love to meet you that way. And then the person that started us off this morning by saying hi, that's Kim. Kim Woodring is our extension agent in Toole County, up there, Shelby, quite a ways away. And she has been a co-host with me for this series of 8, and it's been a lot of fun. And gee, Kim, I'm going to miss you when we don't meet every Friday. We also want to recognize our webinar assistant. This is Carrie, and I swear I couldn't do this without Carrie. She is the one that does the websites. I don't know how to do a website. She is the one that puts all those resources on there for you to be able to check and download to give you some more information to read. And it's just really great that she works with us so closely. And I'm excited to share with you that we're going to have the 4-H Center for Development Director. That's Todd, and he'll be joining us at the end of this session, right before we answer some questions. Oh, wow. We have had 182 Montanans sign up for our Fabulous Fridays, and we're very excited about that. So you can see you guys are from all over the state. And for me, I just look at that and say, wow, this is great because we're able to reach you and share information about estate planning. And those of you from out of state, hey, we give you a warm Montana welcome. We're glad to have you join us. So Kim, we always do some audience engagement tools. So what are we going to use today? Anything different?
I don't know about different, but we have our usual pine drop that reminds us that there is an opportunity to write your questions in the chat, and we will stop what we're doing and answer them for you if you have a question for us. We also wanted to remind you that we will remain in the WebEx room for 15 minutes to answer any questions after the webinar. And we'll start out with our first audience engagement poll. And the question is, what actions did you take as a result of last Friday's session? Did you A, read the Mont Guide about selecting an attorney, B, search the web for an attorney? Did you C, look up an attorney in the yellow pages? How about D, ask a friend to recommend an attorney? Did you E, ask relatives to recommend an attorney? Or F, talked with an attorney about estate planning? Or G, other? Please explain in the chat room. So you can select more than one and hit the submit button, and we'll see what you put down.
And see, this is another thing Carrie does is she develops the polls and then she brings them up for us in this program. So you see, it takes 3 of us to do a webinar and to do it very professionally, I think. So yay, Carrie. Yay.
It helps us from being distracted.
Yeah, I can't do 2 things.
Marsha, this poll was changed, and so it's a little bit different. I'm sorry.
Oh, it's not your fault. That's right. Carrie and I practiced yesterday, and we decided to add talk with an attorney, which is F. So if you did that, would you please go ahead and put that in the chat room? So again, not Carrie's fault, it was ours. As a matter of fact, I was looking at some of the slides and I was still changing them while the music was meeting because I just noticed different things, as Carrie would tell you. And Kim, when we practiced, I saw about 10 or 12 things that I needed to fix. So, you know, that tells you you've got the most up-to-date slide set there is. So I'm looking at the results here, Kim, and I'll just pull it out where you can see that.
Yeah, looks like 21% said they read the Mont Guide. That's awesome. Those Mont Guides are on our Fabulous Friday website, by the way. 14 said they searched for an attorney on the web. 14 said others, so I'm excited to see what they say.
Yeah, great.
have
Well,
any
make sure that
thoughts?
you, and even if you think of something later that you did, feel free to add that in the chat room because we try to go over those. And if there's anybody that has a special question, I try to get to that. But sometimes I'm a couple of days behind, so be careful about hurrying or expecting a response right now. Okay, let's see what else we got going on.
All right.
Oh, it seems like Kim's internet service is not currently available and it will resume. So in the meantime, I'll just take over and say that we're still going to have some estate planning trivia where the winner is going to receive a wildflower card. So this is my very first question for you. What is the dollar amount of the Montana Homestead Declaration? Okay, if you file a Montana Homestead Declaration, you can, well, let's look at it this way. You can prevent creditors accessing a certain dollar amount. So this would be handy in the case of an individual, let's say a spouse that, well, got dependent on drugs or something like that. And anyway, has all these creditors trying to get money because the bills weren't paid. Well, what is the amount of protection that you can have equity in your home? That's what the question is about. So I'll give you a couple of seconds. And Kim, I see you're back. We lost you through the internet system, or I thought maybe you took off to the moon. But I went ahead and just ad-libbed for you there. So we're just ready for the next thing.
Yeah, sorry about that. It just kind of went away and I was talking to myself.
Yeah.
So Marsha, you are our wildflower enthusiast. Start us off with your wildflowers that will help us remind ourselves about today's webinar.
All right. Well, the main thing about the wildflowers is it's just my attempt to try to be a little bit clever and use the names of the wildflowers as ways to help you remember some of the things about the program. For example, we have a steer's head. Now, if you look at this really closely, you can see that it is a steer. You see the ears that are there, you see the nose. I even love the little eyes that they have. It's really a neat flower. And so what I want to do is steer you, or rather Kim and I want to do, is steer you to how you can access these financial accounts when they're owned jointly, because there's a different procedure if they're owned jointly. There's also an opportunity to steer you to how do you do this when you have one owner and designated beneficiaries. Then we have individuals out there that have an account that's in their name only. And so if you don't have a beneficiary, well, what happens then? So that's what we want to tell you about today. And we do have a publication that Carrie listed in the Fabulous Fridays website. So you can go there, you can download that and get more details about what we're talking about today. And let's just look at how they're owned jointly. Let's look at the account when the parents and the kids own together. So what we're looking here is, first of all, that happens is somebody may come in and they know that they're a POD beneficiary or that they have a joint tenancy. So the first thing the financial institution is going to do is review the documents. Okay, they want to make sure that they know how they were signed and really who the financial institution is responsible to make that money available. So let's keep in mind that if we have a joint tenancy with right of survivorship on a financial account, either person or either one of the three can go in and technically withdraw all of that amount if they want to. You see, a joint tenant is a co-owner. So you can access it anytime while you're living, and after an individual dies, there's really no change in the sense that that surviving joint tenant can access. So let's say that we've got a mom and a kid here. So we've got Sarah and Debbie. And what they've done is, well, it's Sarah, really. Sarah is the mom, and she wants Debbie to have her name on the account. So Debbie is, and the idea of that account was to have Debbie pay the bills. But it also works this way when one of them dies. If Sarah dies, then what happens is that $100,000 that's in the account goes over to Debbie. Okay, and if we have the reverse of that, Debbie is the one that dies, then everything in the account goes over to Sarah. Okay, so the advantage there is, of course, there's no Montana inheritance tax, there's no federal estate tax, and voila, there is no probate of that because the surviving joint tenant receives all. So that's the easiest one. But is it the wisest one? Now let's take a look. Let's now say that what Sarah decided to do is going to have Susan. Okay, we have a new family, but the same name of the mom. And she has added Susan to that account, but not the other two. And of course, we've heard this from a prior meeting that if Sarah dies, well, yeah, it's Susan that takes over, and she receives the full $90,000. And mom is saying, oh, I'm sure she will share with Carrie and Jane. And I used to ask this in my public meetings, do you think that Susan's going to share? You know what people say, Kim? Yeah, I can see you shaking your head. No. Well, we'd like to think Susan was better than that. But anyway, so here's mom. And we're trying to educate mom. So mom's still alive. Yay. So one of the things she could do is make all of her daughters joint tenants. And of course, I would visit with her about that and say, oh, there's consequences to that. But we don't have time for that. We've talked about it in another meeting. But that's what she does. She puts joint tenancy for all of them. Okay, so Sarah dies. Well, what happens is we've got daughter Susan with $30,000. We've got daughter Carrie with $30,000. And we had daughter Jane receive $30,000. And Kim, when we were practicing yesterday, would smile and say, yeah, that's a good idea. And I was just waiting for Kim to say that because I said, what happens if daughter Susan gets to the bank first? You see, she is a joint tenant, and that nasty kid could get in there and take it all. Now, let's not provide that temptation with that family, you know? And this is what I love. The joint tenancy, according to the institutions, is a disagreement between the owners, not the financial institution. You see, the financial institution would have to give all $90,000 to, let's see, who was it? Susan, because Susan got in there first. That's one of the disadvantages of a joint tenancy during living. She could have gone in there and just robbed it. Well, it wouldn't be robbing, but she's a joint tenant. So let's watch for that. So joint tenancy between parents and kids may not be your best estate planning tool, even if that's what they talked about at the coffee shop. Let's think about that. So here's our second objective here, Kim. And can you steer us to show what happens with our Todds?
Absolutely. So we are going to use the Mountain Death Canvas for this example. This will help us remember about the PODs, which are payable on death designations on financial institution records. And we covered these in a few previous webinars, but we're going to talk about them again. So some examples of these financial accounts are savings accounts, checking accounts, certificates of deposit, U.S. savings bonds, and our favorite charities or nonprofits like the Montana 4-H Foundation. So the PODs are payable on death, and at death, the ownership passes to the POD beneficiaries of these accounts. And the PODs are nice because they require no probate. They just require you to show an affidavit of death and the government issued photo ID. So we have an example of Jim. He has $5,000 or $50,000 in his POD, and he names each child as a beneficiary in his pod. So you can see his 5 children there. Jim has, again, $50,000 in savings, and on the pods, the bank will write a check to each child for $10,000. And that's better than the last example because the bank will write a check to each sibling instead of one sibling going to the bank and getting all the money. So on this slide, you can see that each child got their $10,000. And so we will take our tip from our mountain death canvas to use pods to control the distribution of checking, saving, CDs, U.S. savings bonds to avoid probate fees at death. So we just used the mountain death canvas, and now we will talk about the meadow death canvas to remind us of the Todds. These are your transfer on death registration, and they, for example, these are your stocks, bonds, mutual funds, your charities and nonprofits like the Montana Community Foundation, and again, our favorite, the Montana 4-H Foundation. So your Todds are transferred to your beneficiaries without probate. So in this example, Jim had $50,000 in stocks, and he had a Todd that names each child. So each child will get 1/5 of the stock, and they can decide to sell or keep their 1/5 after Jim has passed away. So our tip from our Meadow Death Canvas is to use Todds to control the distribution of stocks, bonds, and mutual funds and avoid probate fees at death.
Marsha, you got a
That should be
question?
for you. Oh, go ahead.
Oh, sorry. Can you have a POD if you have a living trust?
Okay, let's say that you've got a living trust. So that means that you have changed the title of the, whatever it is, you know, let's say it's a CD and it's in the name of the trust. And then what we've got to do is think about whether or not we have a trust agreement that's already determining where that goes. But certainly, you know, it's already owned by the trust. So once you die, it goes into the trust. And so you can overdo it and say a POD to the trust, but it's already in there because you titled it into the name of the trust. So when you die, it still goes into the name of that trust. Okay, so the trust agreement is determining where it goes. Now, if you have a testamentary trust, that's one you establish for when you're gone. So like I would have an account and say it's Marsha Goetting's account. And then I want it to go into a trust upon my death. So I say as my POD or my TOD, the trust established at death, blah, blah. So that depends on whether it's living or the testamentary. Okay, Carrie, any other question right now?
No.
Okay.
That was a good question. So we will do our next trivia question. What is the dollar amount of the Montana homestead allowance? Please put your answers in the chat, and the first person to get it right will receive a note card.
Okay, and I'll just throw out for you, Kim, there, that dollar amount of the homestead allowance is protection for the surviving spouse and minor children. So if you want to, you know, the homestead declaration, think of that as while you're alive, and this homestead allowance is after you're gone. What kind of protection does the estate have? And I'm just saying the legislature has looked up these different things. So they have exempt property, they have something else, and homestead allowance.
All right, Marsha, can you steer our participants to learn how to access accounts when the deceased was the only owner and no beneficiary was designated?
Okay, I'd be glad to, because what we've got here is a person that did no estate planning. They've got everything in one person's name. So what the legislature's done now is to say, okay, what we've got to do is establish the value of the estate. And if it's more than 50,000, then we're going to use these procedures. If it's less than 50,000, then we have different procedures, because they're saying, you know, if you're not careful, you're going to spend more getting it transferred than what you've got if you're not careful. So we're looking at those two dollar amount differences. And I re-looked at this some of this stuff, and I found that the values, when we're trying to get to that $50,000, does not include the value of PODs, TODs, and joint tenancies. So you see, you could have a lot of money passing by PODs, TODs, and joint tenancies. And then you have this one thing out there that's maybe a $25,000 CD. Okay, you can use this procedure. And let's see what Granny Richardson did. She has an estate, and we're going to call it small. Okay. And when we did the value of what she has, we found that it wasn't over the 50,000. And I have in here less liens and encumbrances. And, you know, Granny didn't have any of those because she had the mortgage paid off. She had other kinds of things that were done there. So when the procedure is less than that $50,000, you don't have to have a probate, and you do not have to have a personal representative appointed. They call this collection of personal property by affidavit. So after someone passes away, and if there's less than $50,000 in that amount, then we wait the 30 days. Okay, so we can't go trotting into the bank or some other place 5 days after somebody's dead. And you know, we need to grieve here. Let's be a little serious. Let's take time. Let's do things that need to be done. And then we take our affidavit. Okay, and this affidavit has to be notarized in front of a notary public. And this is the person that has you take out your ID and prove who you say you are, you know, so there's a sign. Now, there is a catch to this, is it can't be used for real property. Of course, when would we find some real property in Montana anymore that's worth less than the 50,000? But anyway, moving along. So this affidavit is presented by either the devotee, and this is what they refer to your heirs in a will. It's a devotee. You ever read your will and see that strange language that's used? And then heirs is the term that's used when there's no will that was written. So that this person then can go ahead and take they've got legal authority, and they can collect the assets that are in the financial accounts. So all they'll need is this photo ID and that affidavit that is signed and notarized. And what Carrie did was put this up at our Fabulous Fridays website. So we've got the Mont Guide on that topic, and we also had the affidavit that's there. So the tip from Richardson's Geranium is we can use for a small estate a collection of personal property by affidavit, and the value that we're looking at there is under $50,000. Now, Kim, would you share information about the procedures when the estate is 50,000 or more?
Absolutely. We will be using the wood lily to remind us of this part of the webinar. So we will be talking about a personal representative. So what is a personal representative? They are the person giving legal authority to carry out the settlement of your estate. And we have a poll question for everyone. Have you personally served as a personal representative for an estate? Yes or no? And don't forget to hit that submit button. Have you served as a PR, Marsha?
You know, I haven't. After all these years I've been doing this, I was a daughter of a parents that passed away, but in my home state of Kansas, they require that you be a resident. So I couldn't even practice what I preach here because my sister was the one that wound up doing all that. And bless her heart, you know, if you've been one, you kind of know that there's a lot of work involved. So
Mhm.
we've got, wow, look at that, Kim.
Yeah. Wow. 7 on our webinar have been a PR before, and 17 have not. I have not either. I've witnessed some wills when I was at the law office, but I never was a PR.
Well, and let me encourage then some of you that have served as a personal representative. You know, we won't use your name, but if there's any advice that you would like to share or just a short bit that you can put in the chat room, we would welcome those kind of comments because this is an opportunity for us to learn from one another.
Absolutely. So this is kind of a difficult slide for me to describe, but it is a concern about costs of hiring an attorney. So if you do not have funds to hire an attorney right now, there is a website that you can access from the Justice Commission's Self-Represented Litigants Committee, which is a mouthful to say, but they have a group of documents about how to administer a small estate. So they have about 29 pages and they are on our Fabulous Friday websites. You can, a lot of times this is used for if there is a divorce or if you need help with deciding out how to make your parental plans. So yeah, you can use those on our website. So some of the forms in that are the affidavit of service, the notice to creditors, the proof of service by publication, and the deed of distribution. There's also an application for informal probate of will, an application for appointment of personal representative, and an application and letters of appointment, and also a notice and information to heirs and devisees.
Yeah, Kim, and I'll throw in here, I've had lots and lots of people request this particular publication, and they recently updated it, which is good. And this is really the Supreme Court's mandate that there be these kinds of forms made available, particularly to individuals that simply cannot afford legal assistance. And, you know, and then there's some, you know, you say, well, go to Montana Legal Services. Well, yeah, but you've got some income things that you have to apply for. And this is a way that those that aren't low enough can still have assistance if they're willing to do that.
Yes. So this is our Wood Lily again, reminding us that you would investigate 2 probate choices. One, to hire an attorney and selects the appropriate type of probate, or the personal representative will decide to handle the paperwork. So the types of probate are informal proceedings, formal proceedings, supervised administration, and small estate summary administration. So our first informal probate proceedings, the first step, you would complete the application for appointment of personal representative no sooner than 120 hours or 5 days after the decedent's death, and you need to pay a $100 fee to initiate the process with the clerk of district court. Your PR would also initiate by providing the will to the clerk of district court, and the clerk of court would present a letter of appointment to the personal representative. Our second example is our formal probate proceedings, and this would be used if no will exists, or if the validity of the will is in question, or if the parties disagree about the appointment of personal representative or the distribution of assets. There might be an example that the person might have 2 wills that somebody thinks that they know about, or they might just have questions about the will that they have.
Or maybe an attorney can already tell that there's going to be disagreement among kids because, you know, small towns, there are no secrets, and you can just tell right away there's going to be a big fight. You know, I've even heard people say, "Oh, why bother to do a will because it can be beat by any of my kids." Well, no, there's 3 ways that we learned that you have to prove the person was incompetent or they were under undue influence, or the 3rd requirement is that you be at least age 18. And I dare say you wouldn't be watching this series if you weren't over age 18.
Right. So our 3rd example of probate is supervised administration. So this is administration and settlement of the decedent's estate. This would be under continuing authority of the court and can occur informal or formal probate. So Marsha told me about a situation of some cherry trees in the Flathead. This was a supervised administration. So someone else is hired to pick the cherries as a protection for the estate. Did I get that right, Marsha? That was my little note.
Yeah, it was one of those situations where there weren't any of the children in Montana. They couldn't find the will. It was just really an unfortunate situation. So, you know, some person said, well, these cherries got to be picked. And so the court did appoint someone to just, you know, temporarily take care of that until they had the children notified and they could get to Montana and handle some of the situation there. So there's not one way of doing probate in Montana. And I suppose I just heard the term probate and assumed it was always the same. Well, by studying this information and doing the Mont guides was a way that I found it, aha, there are different ways in Montana, and that helps us lower the cost of probate as well.
Thanks. So this personal representative would get permission from the district judge to take action for the estate. So they hired somebody to pick the cherries while the PRs were on their way here, right?
Mm-hmm.
Yes. Okay. So your supervised administration, again, would extend until the entry of the order approving distribution of estate, discharge of the personal representative, and other orders issued by the court for terminating proceedings. So our last option of probate is the small estate summary administrative procedure. This would be used if inventory and appraisal reveals that the value, less liens and encumbrances, does not exceed $64,500. So this has your homestead allowance, your personal property, and your family allowance to equal $64,500.
Yeah, and Kim, this recently went up. The homestead allowance used to be $20,000. And I'd heard that it had gone up. So I thought, well, about time, because I knew it had been that amount for 30 years. And then I found out it had only increased by $2,500. And I went, well, why? I'm sorry, that's being snarky, but you know, it would have been a good idea to maybe put an inflation factor in these, because we know in 30 years, well, anyway, that would be something for them to think about next time around. Maybe they'd ask me and I'd give my opinion.
Yeah, I don't know why they don't.
Yeah, right.
So your PR would add the cost of expenses of administration of the estate. They would add the funeral expenses and the medical and hospital expenses of the last illness. The PR, without giving notice to creditors, would immediately distribute the estate to persons entitled, and they will file a closing statement. So your PR or family member would use one of these 5 types of procedures in Montana: the collection of personal property by affidavit, informal proceedings, formal proceedings, supervised administration, and small estate summary administration.
So those are the five. Wow. You know, and some of them kind of combined. And well, I'll be interested in hearing from some of our probate folks on which type did you select to do, or what type did your attorney do, or did you even, you know, was that information made available to you?
So this is our tip from the Wood Lily. As a personal representative or family member, you would explore the 5 different types of procedures of probate. So Marsha, will you steer our participants towards learning more about probate costs?
Oh, I'd love to talk about money. That's the other aspect of what things I do. And for this particular one, I'm going to use the penstemons. Now, if you look at a penstemon like this, you can see, to me, they look like a mouth. I know that's stretching it just a bit, Kim, but I'm going to call them the screaming or the complaining penstemons, because when I talk to people about why do you want to avoid probate, it always gets down to money. They've heard it's expensive, and it's not as expensive as other states, but yeah, if there's a way that we can reduce costs so we have more for our heirs, that sounds like a good idea to me. So let's look at cost of probate real quickly, what it was before, then I'll tell you what it is now, because this is very relevant. You see, like other states, we did percentages. So Montana said there is a statutory limit for the PR, personal representative, and also for the attorney. So they did it on the value that passes through probate. Okay, so it was 3% of the first $40,000 that goes through probate, and then 2% after that. So you could take a value of an estate, like a mom that had $200,000, and if the attorney charged the maximum, which in this case then, you see the attorney was allowed 1 1/2 times what was allowable to the personal representative. So what was allowable? So this was an example of an estate. This was a mom that had a home, a CD, and some mutual funds. Okay, we do the calculation, and the PR would have received $4,400. And then the attorney would receive $6,600. So the statutory limit for that would have been $11,000 on a $200,000 estate. But I told you it was a home. So what we need to do is just change the name of the home to the daughter. The CD, not a biggie. We figure out how to go to the bank and get that taken care of. And the mutual funds. And you see, mom, when she died in this case, didn't know, because we didn't have these allowed in Montana. She could have done a transfer on death deed for the house. She could have done a POD on that certificate of deposit, and she could have done a TOD on the mutual funds and avoided all those costs. Okay. So if you take an example of a larger estate, you see the dollar amount, of course, grows by the dollar amount of the estate. So on a $2 million estate, the amount that could have been paid to the personal representative was this much. So there was kind of a big concern about using this statutory limit, which seemed to be that's what most of the attorneys were charging. And there were a group of attorneys that felt that it should be based on the trouble that it takes or the time that it takes to settle an estate. So all of you that do estate planning, you got it organized, it should cost less. Good for you. I agree with that. So here is what is happening now. They eliminated the statutory percentages. Okay, so they passed a new statute, and the new statute says the fee must be reasonable. I'll say that again. The fee must be reasonable. And I could see Kim laughing because she's thinking, what might be reasonable to Marsha may not be reasonable to Kim. And that's the response that I've gotten. Every time I say this, people look at me and they laugh. And they go, you've got to be kidding. And no, that's what it says in the law. I looked it up too, because I thought, surely not. But they're trying to say, okay, what we're going to do is look at hourly and what that attorney charges. So that means they're going to keep track of how much time they spend on doing the estate instead of simply going through and figuring it based on the value. So we can go back to this $200 estate, and I will let you decide. Do you think that the $11,000 fee is reasonable? And don't forget, 4,400 was the PR, and then 6,600 was the attorney fee on this estate. Now, I happen to know this situation, and what happened here is that, you know, I told you mom had a house, and so we had a deed to work with. Whatever, the attorney only charged $400 because that attorney was in a community where there was a lot more competition. Okay, this is even before the new law came into effect about reasonable. So the charge was $400 for that particular estate. So my tip from the Pinstaman is simply ask the attorney, you know, you realize that it's supposed to be reasonable, because I just had a call this week from a woman, and she's concerned about the attorney. And I said, well, what did he say or she say about the charge? And this is what she said. The attorney said it would be 3% of the first 40,000 and 2% in excess of that. And I said, whoa, wait a minute. That's no longer appropriate. It needs to be the hourly fee. It needs to be reasonable, in other words. So Kim, steer us to some information about probate and income taxes.
All right, so we are using the blue flax for this example. And my dad planted some blue flax a few years ago, and it was very beautiful. The blue across the sky, or the horizon, was very cool to see. So we wanted to introduce Gary Blue and his three children, blue children. They are Linda Blue, Matt Blue, and Rita Blue. So who can be Gary's personal representative? This is the person that he nominated in the will, and the statute priority says that if no will, it could go to the surviving spouse or spouses, whatever, the adult child or children, the adult grandchild or grandchildren, the siblings, the public administrator, or 45 days after the death of the decedent, it could go to any creditor, which doesn't sound ideal. So Gary Blue nominated his daughter Linda Blue in his will as a personal representative. So Gary passes away, and Linda decides to hire an attorney to handle the paperwork involved in the estate. And the attorney tells Linda, do not take the personal representative fee. And Marsha's, why? Why?
Well, yeah, most people think the attorney gets more. You know, that's why they're saying don't take the fee.
Mm-hmm.
So what do you think, Kim?
Well, I would have thought that too, but now that I know now that I know, the PR fees are subject to income taxes through your Montana taxes and your federal taxes. And the amount depends on the tax rate, and there's a new rate in 2022, which is 6.7% if taxable income is $19,800 or above. So the Montana taxes are 6.75%, and the federal taxes are 24%. So the amount lost to taxes for the PR fee, if your fee is $4,400, your Montana taxes that they take out are $297, your federal taxes that they took out are $1,056, you have a total loss of $1,353. So that is why you should not take a personal representative fee. So Gary's family, again, has the three children, and Linda is appointed to the personal representative. She is wants to take a vacation, and she needs to take vacation time to settle her estate, and she experiences hassles with her siblings. So she decides to take the PR fee and go on a vacation where she's in Mexico drinking margaritas. And she takes the money without consulting the siblings. So that wasn't very nice of her.
Well, on the other hand, wait a minute, I'm going to take the daughter's side here. You know, she's really trying to do the right thing here for the family. And then you get, okay, when are you going to give us the money? And when are you going to do this? And when are you going to do that? And so she says, you know, I am going to take a reasonable fee. And she will, yes, lose some to taxes, but she also then technically gets more than the other two kids, which by now she feels she's deserved because of the hassles from the other two. So I know the background there, so that's why I'm saying that.
Perfect. So our tips from our blue flags are to ask the attorney about the hourly rate and ask about the PR's hourly rate to be charged. So Marsha, how long does probate take?
Well, that's what we're gonna, might as well ask our crew about this. What do you think is the average time that it takes to settle an estate in Montana? 24 months, 18 months, 12, 10, or 6? And if you talk to an average Montanan, they just think it takes forever, absolutely forever. But that's not true. So check A, B, C, D, E, or no F, and hit the submit button and let us know what you think.
Marsha, someone asked, what is this flower?
I'm sorry?
Marsha, someone asked what that flower was on the screen.
Oh, yes. That is a green gentian. And the reason I was using it, I forgot to explain, is because one of those takes forever before it blooms. So I've seen some that are 15 years old that are about this high, and you know, it takes a while. And that was what people think that probate takes, is that long. So I've actually seen some of these green gentians that are as tall as I am in Yellowstone National Park. Okay, what's our result here? Okay, 29% thought it was a year. 24% said 10 months, and that's actually what we have got here. Is the average is 10 months in Montana. Okay, but if it isn't closed in 2 years, the Supreme Court administrator notifies the district judge, and the district judge can call in the personal representative and the attorney and say, hey, what's going on here? Well, there could be a legitimate reason. Maybe we're waiting for the house to be sold. Maybe we've had trouble trying to sell property. You know, not now. Property's going like crazy in Montana, but you can reach a stage where there's a problem. And there have been times, quite frankly, that there has been misuse of funds in an estate situation. So we have had at least 4 attorneys disbarred in Montana for not taking care of what they needed to do with the estate. So we've got, again, to review for you that probate and personal representative mock guides would be good for you to take a look at. Well, Kim, I'm seeing that the fairy slipper is saying, or the lady slipper, excuse me, is saying, oh, our time has slipped away. Yeah, because we want to have some questions here for Todd. And the dollar amount of the Montana Homestead Declaration is $350,000. It went up with the last legislative session. And the dollar amount, we've already told you about the homestead allowance, and it's $22,500. So think of those $2 differences. If you don't have a memory like the elephant's head, hey, we've got those mock guides at the Fabulous Friday website that are specific for each one of the Fabulous Fridays we've done. Carrie has also made a website for me with all 50 and has descriptions there. So yay, we got 50 different mock guides. And don't forget, those are also available at our county extension offices, like up there in Toole County with Kent. advertisement here real quick. Wednesday Wisdom. I'm going to be doing some sessions for AARP on April 6th, May 11th, and June the 8th. So we really do appreciate your participation in our webinar series, Fabulous Fridays, for the last couple of months. And we'd like for you to share your thoughts about the webinars, because we will be looking at these very closely to determine what are we going to do for next fall. We found summer isn't a good time with everything else that's going on, but fall and spring are good times. So I'm going to introduce our special guest here, Todd. And Todd is going to be interviewed here by Kim once I stop sharing. And we can see Todd. Todd, are you there?
I am here. Thank you very much.
He is there. Great. Okay. Well,
It looks like
Kim
I'm in the
is
dark.
going to.
Am I in the
I'm
dark
sorry.
in your end? It looks like I'm in the dark.
You're better there.
Okay, I'll lean over this way. Yeah, thank you so much for having me, both of you, and Carrie for setting this up. But what a great program! I tuned in today, Marsha, because I'm going through this very thing, and you guys have been very, very helpful. So thank you for that.
Thanks.
Yeah, glad you could join us. Sorry about that. Todd, we have some questions for you. And my first one is, how did you get started as the director of 4-H and youth development?
As the director, well, it took a long time because I started out as county agent, and as county agent, much like Kim is now, for 18 and a half years. And then position came open at the state level, and having been the county agent in Gallatin County, it was an easy transition to campus. I just drove to a different office, and it required a doctorate, so I had to go through a little more schooling. I added it up. If I add kindergarten through my doctorate degree, I was been in school for 32 years. So it was a lot of work. But then about 5.5 years ago, it was opportunity arose to be the director of the Montana 4-H program, and applied for that and received that, and I've been really, really honored to serve in this role ever since.
Thank you. And we're glad to have you. It's been fun. What are some of your upcoming projects in 4-H?
We're excited because this is going to be the first summer where we're not dealing with COVID restrictions. And the first summer this COVID thing hit, it was difficult to put on fairs. We couldn't invite the public. It got a little easier last summer, but still a lot of stress on our county agents and on our volunteers. And so looking forward to a camping season that's going to be a little less stressful. We have thousands of kids that go to 4-H camp across the state in their counties, and so we're looking forward to that. And a fair season where hopefully we don't get another variant and whatever else is coming down the road, but hopefully we can have a lot less stressful fair season as well. So those are the big things. We do have a team leadership conference on campus right after the week after the 4th of July. It's Montana 4-H Congress. And we usually get about 300 teens that come and attend that. And it's our state contests, from everything from public speaking to livestock judging, and a lot of communication awards and contests there. But also for kids that aren't competing, or for all the kids there's some really great leadership experiences and leadership education programs for those kids to take. So we're trying to take these teens and enhance their ability to lead and to work within a county program and go back home and be volunteers and resource people themselves. And so 4-H Congress is a big part of our summer, and it's a week here on campus, and young people get that campus experience. They stay in the dorms, they eat at the cafeteria, they find their way around to different departments on campus, get some tours. And it's a good recruiting tool for MSU, but in reality, it's also a great leadership opportunity, and that's really what it's all about.
Well, and speaking of leadership, sorry, Kim, I just thought of
you're
this.
good.
What about the ambassadors? How many ambassadors do you train each year?
We have a state officer team of 5 teens that are selected from a group that put in an application. those are the state officers, but each county can have as many ambassadors as they would like. And those ambassadors are teenagers who are interested in enhancing their leadership skills. So when we have a fall ambassador training and invite all those kids, not just the state officers, but all of the kids that are representing their counties, we can get up to 200 teams that are across the state fulfilling that official ambassador role. A couple here, a couple there across our 56 counties and 7 reservations. And so we've got a lot of more teams than 200, but we got 200 that have taken real interest in that leadership opportunity.
I didn't have any that wanted to go to Congress last year, so I missed it. I was really bummed because I've had fun at Congress too.
It is. It's tiring for the adults, but it's also really fun to see the kids grow. And then there's always something I pick up out of it as well.
Absolutely. Did you get to go to Rec Lab? We talked about Rec Lab a bunch on our past webinars.
Yeah, I did not. I just fell on a date that I could not get up there, although we did have people from the 4-H Center there helping with that. And reports are it was absolutely fantastic. So that is for the folks out there that weren't part of that broadcast last time. That is another teen leadership conference that is kind of centered around recreation and how to teach through recreational type activities. And a lot of it can apply to your 4-H camp and places where you've got groups of younger kids where the teens can be leaders. And then what do you do with those young kids? So a lot of workshops on how to interact with younger 4-Hers as a teen, and take that to your camp or any other opportunity you might have within your county.
Yeah, I went down and taught a few workshops. It was a blast. There were a lot of kids there. One of my questions for you, Todd, is where do you see 4-H going in the future?
Well, I see we're working really, really hard and making 4-H any young person who'd like to join or be part of 4-H, we want them to have the access to the program. And so we're working really hard on that. It's very easy for a young person to participate when they have supporting parents. There are kids that have parents that are working 2-3 jobs. They're just trying to get by. They'd like to be part of 4-H, but they've got nobody to take them to the club meeting, nobody to take them to the project meeting. They're missing out on the educational opportunities because they don't have the transportation. They don't have the parent that can do it. And so we're working on ways to be able to reach those young people. The goal of the program is to move young people from childhood, adolescence through their teen years and become functioning adults within their community that make that transition in a positive way and contribute to their community when they become an adult. And you can't do that if you can't get a kid in the program. So I see us working very, very hard on reaching out to some communities and some demographics within those communities to help those young people that can't normally get to a 4-H club meeting, get them involved, because they deserve to have the leadership skills, the confidence building, the sense of mattering, the hopeful future, and the thought that I can make a difference in the future and I have control of my own life. And that helps you transition positively into an adult role. And if we can't get you there, you're missing out on that. And working hard and coming up with strategies and how are we going to help those kids get into the program, and what kind of things we need to set up in our communities, and how can our kids help those kids get into the program, because nobody identifies an interested prospective 4-H'er better than kids that are already in the 4-H program. So our young people are absolutely our best recruiters, and our parents are as well. But there's no population within the state of Montana of young people who don't belong in 4-H. And I've heard that those kids aren't 4-H'ers because they don't live in a certain place or participate in a certain project. And it's like baloney. Every kid in the state can be a 4-H youth, and there's something for everyone. You don't always have to raise a pig. You can be in robotics, you can be in drones, you can be in computer programming, you can be in photography, you can be in wildlife, you can be in dog agility. There's a million things for young people to do that doesn't require you have property and raise livestock. So definitely going to continue to have that part of the program very strong, but continue to reach into these other areas. Doesn't matter what the project is. That's that transition to adulthood is what we're looking for. And we're going to reach those kids and watch 4-H expand.
Absolutely. I was going to say that you're right. It does. You don't just need to have a pig to do 4-H. Like we have projects for everything. We have cat, dog. It doesn't even have to be an animal either. Like you said, robotics. And I saw a big jump in our shooting sports numbers this year. So we have archery and shotgun, and those kinds of projects are huge. And the accessibility, the amount of scholarships that we can give out, like if it's hard for you to afford to go to things like Rec Lab, we have scholarships to help anybody out that wants to go.
Yeah, and those kind of things they're well set up in your county, Kim, and in a lot of counties they are. There's funding there for that. Some counties there aren't, and sometimes it's up to the kids to get together and have a fundraiser too. Because we don't believe that you just get to go to everything for free. You got to work for it. And that's part of that transition to adulthood as well, is that if you participate in a fundraiser, you're making a difference and you're advocating for yourself and your friends that are going to go on a particular excursion, and it costs money. And it really isn't the community's responsibility to send these kids, when it comes right down to it. It's the kids can help a lot. And there's always great donors who help us out. They help us out a lot more willingly when they see the kids working. And so a lot of these counties have set up places for fundraising dollars to go that have been raised by kids that are out there beating the bushes and making things happen. And that's makes you feel better as a donor. I give to the Montana 4-H Foundation as well, every paycheck. And I know what the return on that investment is. And I also know there's a lot of hardworking kids out there that are taking responsibility for themselves, and I don't mind helping those kids out.
Yeah, and I think that's where the people partner grants come in through the 4-H Foundation. These are the ones that they come up with a project that they're going to do in their community, and it's very, very community minded. And these were grants that were started by Jerry Finn, who was way back, in the 60s and 70s with the Montana 4-H program. But she also saw the growth of these kids, just like what Todd is talking about, and and so that's her legacy, are the People Partners grants. A legacy of giving back to the community, but you learn these leadership skills by working together. And some of those kids are clover buds. They're very young, but they're still a part of what's going on. And you have the older kids that are helping them out. And so that's just the greatest thing about the 4-H program. So I'm glad that you guys have been sponsoring us, and we thank you very much for being here. Kim, is there any final question you'd like to ask?
I think he answered all my questions, but thanks for joining us, Todd.
Absolutely. How did I do? Because this was completely impromptu. You guys talked about practice. You left me out of that part. I had no idea what we were.
You'd been on before. It's Kim and I that need the practice. So we knew you could do it. No problem.
Well,
Yeah, you
I sure
nailed it.
appreciate the opportunity. Thank you very much.
Okay,
Thank
so
you for
we're going to
mentioning
thank
4-H.
you. And you're welcome to hang around to hear answers to questions, but that's what we're going to do next. So again, thanks so much, Todd, and we'll
Absolutely.
see you.
Thanks for having me.
Okay, Carrie, what kind of questions do we have?
Okay, Marsha, this is for the other question. The lady asks, so I understand that if you have a living trust, the short answer is POD cannot be applied. It will be distributed according to the trust. Is that correct?
Yeah, see, because you have the item in the name of the trust, it's the trust document that is going to indicate where the money goes. Okay, so you don't want to have a conflict of here having, that's like having a will and a POD. The will says one thing, the POD says another thing, you've got a conflict. So what you want then is, if what you want to have happen is with the trust document, leave it alone. It's the trust document that determines your decision making in there where the asset is going. So we don't have two things that are fighting one another. Okay, next question, Carrie.
Yes. What happens if you outlive your attorney or their practice?
What happens if you what? Outlive?
Outlive your attorney or their practice.
Okay. Yeah, that is a challenge. And now the state bar has set up a system that when an attorney is going to retire or an attorney has passed away, that the state bar be notified. And what they will do is maybe send in a couple of people that are state bar members to sort out the things that happen to be in the office. So what happens is maybe you stored your will with your attorney. So they find that will and they notify you to come in and you pick it up. And so what they're doing is settling out the business there. And so if you've outlived your attorney, maybe now is the time to say, look at the will and does it need updated? Well, if it's been 10 or 15 years, the chances are it might need to be, maybe not, but let's find another attorney in the community or wherever and take that will and say, okay, take a look at this. Do you think it needs to be changed? And the attorney will ask you, well, have your goals changed? Have there been births? Have there been deaths, marriages, some of those kinds of things to see if it does need to be updated. And let's give some of those graduates out of the School of Law that well, it has an official name, but let's short it, School of Law at the University of Montana. We've got some great individuals coming out of our law school there that are taking on estate planning. They have an interest in it. They're getting mentored by some of our more experienced attorneys. And you will find some of them can be really great resources for you. Okay, next.
Marsha, I think that's all the questions, at least I see.
Okay, I did see about the healthcare power of attorney form and where can you include wishes for the organ tissue donation. This first I would have you read, and I included it in the chat room, our body donation Mont Guide. And my reason for doing that is they have specific procedures to be able to take a body in Montana. So I would suggest you go there and see what we say about that. There's a place in the healthcare power of attorney to indicate that, but the specifics about signing things and what have you, you have to follow the Montana donation program to be able to either donate body parts or your whole body. And so that's why I did the Mont Guide, is that almost every other meeting, it seems like I've got folks out there that do want to make that donation. And there is the donor section of your driver's license that can also be an indicator that you want either your organ or your organ donation. Okay. And that's a place that we can do that. So if we do not have any more questions, I guess we've reached that time, and I'm getting emotional thinking about, you get used to doing this, and it's been great meeting with you folks. Even though I haven't been able to see you, I have the sense that you're out there, and you've been with Kim and I all these weeks, and so we're wishing you the best. Any last words that you want to say there, Kim?
Well, I've learned a lot through this webinar too, so thank you guys for joining us, and thank you, Marsha, for asking me to help you with this, and it's been fun.
Well, good. We're doing our own legacy planning, I think, here. So again, everybody be safe, do keep healthy. Yeah, we've heard about this new variant that's going around. So hang in there, and I look forward to seeing you when I'm out in the counties. Take care now. Hi, Carrie, and thanks again.